Hello, and welcome back to Emmy Law's YouTube channel, your go-to source for valuable insights on legal matters. I am your host, founder, and principal lawyer of Emmy Law, and today we are going to be discussing the basics of property purchase to inheritance distribution and understanding the entire estate process. Each area we discuss today can be further elaborated on and developed to fit your needs when you contact a legal advisor. We are a litigation firm, but we have been retained to deal with complex property and estate disputes. The estate process is a very complex and multifaceted area. Depending on your objectives, or what we lawyers like to call your intentions, it can be a long journey that involves various legal, financial, and administrative steps, and often involves the working together of both a lawyer and a financial advisor and a tax advisor. If you are in a high net worth bracket or on the process of moving into that high net worth bracket and you have residential and commercial properties, businesses, investments, and so forth, it is important that you set up your wishes clearly on whether you want to make everything of your assets to be distributed to your beneficiaries, or you want to develop a well-organized plan that will see consistent increase in generational wealth that will continue well after you are gone. I am not saying that this only applies to individuals in the high net worth bracket, but it can apply to anyone. However, it is the high net worth bracket individuals that tend to think and plan more of their passing as they do for their retirement. It is important that you give instructions to your tax advisor, lawyer, which is often a solicitor, investment advisor, and so forth when it comes to your estate. Estate planning changes in your property, ownership, businesses, and investments. It is also important to always ask questions because the law is always changing, and so is your situation. One day you could be rich, the next day you could be poor. One day you can have 10 houses, the next day you can have one house. It's important that you're constantly planning on a year-to-year basis. Some people might say that, well, that is quite difficult to plan on a year-to-year basis, but I would tell you that it's not, especially if your assets are always changing. I would like to give you an example of recently. There's previous years when you had a bare trust, you weren't required to file a T3 return. But this year, the Canadian Revenue Agency will require all Canadians to file a T3 return annually, naming the trustees, settlers, beneficiaries, and controlling person of each trust. This is subject to a few exceptions, but it's very important that you speak to your accountant about this and they will be able to provide you with more details. If you'd like to speak to more about what a bare trust entails, reach out to us and we'll be able to discuss with you the details on how it works. Before I move away from this topic, I would like to stress the fact that if you do intend on setting up a bare trust, you have a lawyer draft it and you understand its purpose. If it's not in writing, you will most likely encounter legal issues to the extent that you or the other party's credibility will most likely be tested in court. Since bare trusts are not only used in estate planning, they can be used for how title to property is. Since our discussion today is about property purchase and ending with inheritance distribution, I touched briefly on both, but now I'm going to be discussing purchasing property. Before you purchase property, you need to do your research and you need to plan your budgeting. We have seen many times before people going crazy and dumping whatever savings they have on pre-construction or resale homes, only to realize that they do not even have the budget to continue with the closings. It is important you first identify the property you want to purchase, you conduct thorough research on the real estate market, and you establish a budget. You need to ask yourself, do I have enough now in terms of money? Will I have enough money later? How much do I need to be making monthly to sustain my expenses now and to allow some of my income to flow into a residential or commercial investment? You should also consider budgeting in case interest rates go up or down or your circumstances change. Budgeting is one thing, but then you also need to secure financing. You will need to secure financing through a mortgage or other means if necessary. You should keep in mind that a mortgage pre-approval today, does not guarantee you being approved for the future and so forth. You can always put financial clauses in your contracts for purchase and sale, and the purchase and sale could be subject to obtaining financing. You should always engage a lawyer promptly to advise you on your rights and obligations under these sorts of contracts. Solicitors that practice in the transactional work related to real estate law are supposed to assist you in reviewing your contracts, making sure that you are protected and that certain stages are followed. For example, property inspections, title searches, and any negotiations before the closing date, and so forth. With regards to a new build, you are given time to have your very lengthy contract, because it's a lot more lengthier than a resale home contract, reviewed by a solicitor before the contract becomes binding. Although you have gone to a legal professional to review your contracts, it is important you ask all the right questions, specifically when it comes to your rights and obligations. For example, your right to reassign the property, penalties for not closing the contract, taxes, and so forth. At the same time as purchasing your property, you might want to also do your estate planning. When you're in the process of drafting your will, you will also want to draft your power of attorney for property and a power of attorney for care. Both require you to designate someone to make decisions on your behalf while you are still alive, but are unable to make those decisions due to various factors, including not having the capacity to make those decisions. The power of attorney for property deals with any property you own, including but not limited to residential and commercial property and bank accounts. When you appoint someone to be your power of attorney for property, that person will make all the decisions related to your property. Power of attorney for care deals with decisions related to your care. For example, if you should go to a retirement home or a care facility, and so forth. When you appoint someone to be your power of attorney for care, you are giving them the ability to make decisions based on your care, if you do not have the capacity to do so. You can also establish trusts for specific assets or beneficiaries. A financial planner, accountant, and a solicitor should be able to provide you guidance on how to structure your trusts and how they work. Once you pass away, the named trustees will start getting to work, reviewing your will, any memorandums left by you, all the documents you organized and kept aside relating to your assets, and so forth. So the trustees don't have to go on a hunt to look for them, and that way they can work on distributing your estate and so forth. The estate trustee should retain a solicitor that deals with estate planning, which will include filing for probate, assisting your estate trustee in obtaining an estate certificate with a will, and will notify the creditors that you have passed, and they will take steps to settle all your outstanding debts and taxes from the estate assets. If there's more than one estate trustee, it is important that each trustee meets each other and set out each other's role, as there can be conflicts that can arise between all the estate trustees, and all the parties would have to take part in litigation, and this would keep the estate in a standstill. To avoid potential future conflict, you can always appoint a professional estate trustee. Your solicitor should be able to guide you down that route if need be. The appointed estate trustee, with the guidance of the solicitor, should also take steps to both value your assets and liquidate your assets. They will do this by conducting an appraisal to determine the value of your assets, which includes real estate investments and personal belongings. They will then liquidate your assets, which involves both selling and distributing your assets as outlined in your will, or if there's no will, you will need to comply with various statutes. For example, in Ontario, there's the Succession Law Reform Act, but also you need to look at the Estates Act and for things related to appointing estate trustees and passing of accounts and the Trustee Act and so forth. The trustee or trustees you appoint will then have to distribute the inheritance left in the will. They will need to take steps to locate and identify potential beneficiaries named in the will, or if they are not named in the will, they will need to take steps to locate the potential beneficiaries, and all the steps taken by the estate trustee or trustees needs to be recorded. Steps to locate potential beneficiaries can include searches on social media, advertisements in newspapers and magazines, hiring professionals that can help you locate the potential beneficiaries, and so forth. The estate trustee or trustees will need to ensure that the distribution of your assets aligns with your wishes. And this is why it's important that you know where your assets are and what they include. You have to plan accordingly. The last thing you want is to leave everything in shambles so that your estate trustee has to figure it out. What assets you have, where they're located, who's holding on to them, what do they include, and so forth. This is why it's important that you engage with professionals who can help you plan for the future. The estate trustee will not only have the job of distributing your assets, but will also have to pay your debts and your taxes. It is recommended that once the estate trustee has your will in their hand, that they start documenting money going into the estate and money going out of the estate. This will assist them in preparing for their final account of the estate's financial transactions. Keeping a record will assist them in the future when they decide to pass their accounts to the courts. Throughout the entire estate process, consulting with legal and financial professionals can help navigate complexities, ensure compliance with the laws, and minimize potential issues. It is important to keep your records of all transactions, communications, and legal documents related to the estate. You also have to remember, as an estate trustee and a potential individual who's making a will, that the estate trustee is entitled to compensation. You can outline the amount in compensation you want the estate trustee to be paid in your will, or you can let the estate trustee, with the help of lawyers, determine that. Remember, today's information isn't legal advice. If you need personalized guidance, reach out to us at 416-606-5405 or by email at office@melaw.ca. If you found this video helpful, don't forget to hit the like button and subscribe for more insightful content. We appreciate your time and look forward to seeing you in our next video. Until then, take care.